So, more than 60% of the country's Fortune 500 companies are incorporated in Delaware. Every in-house lawyer should have at least a passing familiarity with litigation in Delaware's Court of Chancery and the Complex Commercial Litigation Division of the Superior Court, including their special procedures for technology disputes, for mediation, and for arbitration. Chris Viceconte of Gibbons in Delaware defends complex commercial, business, tort, and product liability claims, and he also regularly serves as Delaware counsel for the firm's clients and for out-of-state law firms in a wide range of matters before Delaware's state and federal courts. Chris will explain to us how the Delaware courts are organized, what relief they can render, and how to get great results for your clients in Delaware. Please join me in welcoming Chris.
Thank you, Amy, and good morning. One theme of any talk about Delaware is its size. It's small. As reflected in the state's motto, Small Wonder, Delaware is proud of its size, and much of how the state operates, including its pro-business culture and its court system, is in large part a function of its size. A few statistics. Delaware is the second smallest state geographically. It has fewer than 1 million residents in only 3 counties. Most of the population resides in Newcastle County, which is where the city of Wilmington is located. And most of the state's business and legal community is located in Wilmington, which is just 30 miles south of Philadelphia. In many ways, the state of Delaware is like a small city or town. Another identifying feature of Delaware, among Delawareans at least, is its status as the first state, that is, the first state to ratify the U.S. Constitution. History says that Delaware acted quickly to ratify the Constitution, in part to protect its small statehood. I don't think it's too much of a stretch to say that that history and spirit of acting quickly in the interest of the state and its citizens, including its many corporate citizens, continues today and is one of the reasons Delaware has become the home to so many business entities. As is well known in the business world, Delaware has flexible statutes governing its corporations and other businesses. It also has a strong court system and a well-developed body of corporate law. In the area of contract law, Delaware follows the principle of freedom of contract, which tends toward the more strict interpretation of business contracts. It is each of these factors which, at least in part, has resulted in Delaware's being the state of incorporation of more than 1 million business entities, which is more than its residents, and more than 50%, as mentioned earlier, of all publicly traded companies, including 60% of the Fortune 500 call Delaware their corporate home. No doubt, many of the lawyers in the room have clients who are Delaware businesses. And many of the in-house lawyers and business people may work for Delaware entities or for companies which have business dealings with Delaware companies. Hence our topic here today, the national business litigation practice in a small local court. First, a quick overview of the state court system and the judiciary. With respect to business litigation, it consists of the Court of Chancery and the Superior Court at the trial court level and the Supreme Court at the appellate level. A unique feature of Delaware's trial courts is its distinction between actions at equity and actions at law. Actions at equity are brought in the Court of Chancery, and actions at law are brought in the Superior Court, and for our purposes in the Complex Commercial Litigation Division of the Superior Court, which is the division of the Superior Court which handles matters involving $1 million or more at stake. There's no intermediate appellate level court in Delaware. All appeals go directly to the Supreme Court. So parties have to appeal only once, and they have a right to have their judgment reviewed. Like the state itself, The judges overseeing business litigation in Delaware are a small group. The Supreme Court has 5 members. The Court of Chancery has 5 members, a chancellor and 4 vice chancellors. And while the Superior Court statewide consists of 20 judges, only 4 of those judges are assigned to the CCLD. So in all, there are really only 9 judges at the trial court level overseeing business litigation. Like any other organization, the court system in Delaware is only as good as its people and its procedures. Each of the judges on the Court of Chancery and the CCLD has extensive prior corporate and business litigation experience or relevant judicial experience, and in many cases, both. Delaware judges are appointed by the governor to 12-year terms. A unique feature of appointments in Delaware is that they need to maintain political balance on each of the courts. So, if that need for political balance calls for the appointment of a Republican on one particular court, and the governor is a Democrat, that Democrat governor needs to appoint a Republican. As for the operations of the court, a single judge will oversee your case from beginning to end. Trial dates have meaning. You get a real trial date, and once one is set, it's in the judge's calendar, and parties should and do plan on it. Judges are also required to render decisions within 90 days of submission. In my experience, judges on the Court of Chancery and CCLD and statewide give careful consideration to the matters before them. They read the briefs, they're prepared for argument, and make careful decisions. It's for all those reasons, and perhaps more, that Delaware is regularly ranked number 1 by the U.S. Chamber of Commerce for its fair and reasonable litigation environment. I'll now go into a little more depth about each of the business courts, beginning with the Court of Chancery. In order to qualify for jurisdiction in the Court of Chancery, a party must present either an equitable claim, which is traditionally a shareholder breach fiduciary suit, a claim for equitable relief, such as an injunction, or a specialized claim that falls under one of the corporate statutes which provides for jurisdiction. Legal claims may only be brought in the Court of Chancery if they are secondary or tag along to the primary equitable claim. There are no punitive damages in the Court of Chancery. There are no jury trials in the Court of Chancery. The chancellor or the vice chancellor decides your case. As a result, there are no opening statements or closing arguments at trial. There's heavy pretrial and post-trial briefing. And the rules of evidence at trial, particularly with respect to the admissibility of expert testimony, are generally more relaxed, as the judge can simply discount the testimony without ever having to rule on the admissibility. One of the main features of the Court of Chancery, and something that it's best known for, is its ability to handle expedited proceedings, either by statute or by application. Some of the most notable Court of Chancery cases over the years have been brought and resolved within a matter of days or weeks. As for procedure in the Court of Chancery, the court has issued guidelines with form scheduling orders and discovery protocols and confidentiality agreements for parties to use as a default. The guidelines also provide some of the formerly unwritten rules of the court, believe it or not, even down to the lawyer's attire in court. We don't wear robes as they do in Canada, but it is a formal court. More substantively, the guides provide useful guidance on the court's expectations with respect to e-discovery and privilege issues. Essentially, the overall point of the guidelines, which are in your materials, is to minimize scheduling issues and discovery disputes so that the parties can focus on the merits of their claim. Each of the reference forms in the guidelines are available on the court's website, and they really have become considered a must-read for any Court of Chancery practitioner. Outside the traditional shareholder lawsuit and corporate statutory litigation that regularly happens in the Court of Chancery also has a few unique features focused on the litigation and resolution of commercial business disputes involving Delaware entities that are worth mentioning. First is its technology dispute jurisdiction. The court has special statutory jurisdiction over technology disputes. There's a statute governing that, which is in the materials. Unlike the traditional equity jurisdiction under the technology dispute statute, claims for solely money damages can be brought in the Court of Chancery if they exceed $1 million at stake. In order to qualify as a technology dispute, the claim must arise out of a technology-related agreement, involve a dispute between businesses. Consumer claims don't fall under the statute, and one of the parties must be a Delaware business entity. The parties must consent to jurisdiction either in the agreement that's being brought in the case or in a separate stipulation. The statute defines a technology-related agreement broadly and specifically says that it should be construed broadly to provide jurisdiction in the court. Parties with a qualifying technology dispute may either litigate their case or mediate it in the court before suit, which brings us to the topic of alternative dispute resolution. Two unique features of a Delaware practice in the Court of Chancery with respect to arbitration and mediation of business disputes are as follows. First is the Delaware Rapid Arbitration Act. This was enacted about a year ago. It's a new statute which is designed to accomplish what arbitration was initially meant to accomplish, which is the fast, quick, and efficient resolution of business disputes. While it's a new statute, the thought is that it's best used for businesses that have ongoing relationships, that are comfortable doing away with extensive discovery and extensive appeals and getting their case resolved and moving on. Matters under the Rapid Arbitration Act need to be resolved within 6 months. The agreement must reference the act specifically. The party controls the proceedings by their agreement. Anything that's not mentioned will be default to the act. There's no need for confirmation proceedings. The award is automatically confirmed after the appeal time runs, and any appeals go directly to the Supreme Court and are limited to those allowed under the Federal Arbitration Act. Another feature of ADR in the Court of Chancery is its mediation-only docket. This is a mechanism which allows businesses, prior to ever bringing a lawsuit anywhere, to petition the Court of Chancery and ask for a member of the court to mediate the dispute. This is limited as well to business disputes. One party needs to be a Delaware business, and more than $1 million needs to be at issue for those claims involving only money damages. The price of a petition to mediate is $10,000 to file and $5,000 per day of mediation. While that's certainly a lot of money, compared to private mediation and given the level of service and expertise that you're getting with a member of the court, that's generally viewed as a reasonable price. While less novel, parties may also mediate their cases with another member of the court in pending cases. And the price to do that is $5,000 per day, again, viewed as a very reasonable price given the level of expertise that parties get. Moving on to the Superior Court and the CCLD, the common wisdom used to be that if you were going to litigate a business dispute in Delaware, you'd do anything you could to get it into the Court of Chancery. With the implementation of the CCLD back in 2010, that's really no longer the case. It is designed to serve as a gap filler for those legal claims that don't fit within the subject matter of the Court of Chancery. It includes predictable and uniform procedures and case management orders, which, like the Court of Chancery, are designed to focus the parties on the merits of their claim. All cases in the CCLD reside in Wilmington. In order to qualify for the CCLD, like many of the other qualifications we've heard already today, they're limited to business disputes, $1 million or more in controversy, and you can also get into the CCLD if you have an exclusive choice of court provision. There are a few ways to guarantee that your case gets litigated in Delaware. One, the bylaws of your corporation can require that any internal corporate disputes, like a shareholder lawsuit, be brought in Delaware, and that will be upheld. There's actually a recent amendment to the Delaware General Corporation Law which allows for that. Another is having your contract say that matters must be brought in Delaware, and that's generally upheld as well, as long as there's some reasonable relation to Delaware. And as we've discussed, your status merely as a Delaware business entity also gives you that jurisdiction. The last piece of the Delaware business litigation puzzle is its lawyers. Going with our theme, the Delaware bar is a small bar. There are fewer than 2,500 lawyers in private practice, and of course a subset of those doing the type of work that we're talking about here today. Delaware follows the rule of not 6, but 2 degrees of separation. There's no anonymity in Delaware, and that has necessarily resulted in a way of civil and professional interaction among lawyers and judges alike, which is sometimes referred to as the Delaware way. The courts expect both outside counsel and Delaware counsel to abide in a civil and professional manner. Adopting the Delaware way and working with the other side to move your case along, of course, never jeopardizing your client's interests or prejudicing your case, ultimately will go a long way in furthering your client's interests before the court. So, is Delaware really a small wonder? I'm biased, but I do think it's not too much to say that if you have to be involved in a corporate or a commercial dispute that ends up in litigation and the circumstances allow, it's certainly a good place to have your case resolved. Its judges are among the best, and it has specialized courts with unique procedures. Where the circumstances fit, taking advantage of the court system and its procedures may be worth consideration when, 1, deciding where to form your business, and 2, what governing law, forum selection, and dispute resolution provisions to include in your business contracts. Thank you.